Good morning and welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court in the case of Prickly Bay Waterside Limited and British American Insurance Company Limited, which I'll call BAIC. The case is concerned with a commercial arrangement by which money was made available to the vendor of property by the purchaser in a postponed purchase of land. The question is whether the arrangement involved BAIC holding the money in trust for the purchaser, or whether the money falls within BAIC's insolvency, with the result that the purchaser will rank as a creditor on its insolvent estate. Before inviting counsel to make submissions, I will introduce the panel hearing this appeal. I am Lord Hodge, and sitting with me today is Lady Arden.
Good morning, everyone.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lord Stevens.
Morning.
I now invite Lord Davidson of Glenclover QC to make his submissions on behalf of the appellant.
My Lord, my Lady, I appear on behalf of the appellant, my learned friends, Mr. Bennett with Mr. Bristol appear for the respondent. The case before the board is of relatively short compass. There's a range of areas where the parties are not in contention. The parties agree the principal issue before the board is whether the fund, the $2.475 million, is held by BAIC on a quist close or similar trust since the date of payment by Mrs. Lee. We also agree the legal principles. Legal principles are set out in the case of First Monument Citibank. Researchers suggest this is the most recent statement of the law on resulting trusts. Plainly, it is the application of those legal principles to the facts that are the area of contention. And thirdly, as far as what the Court of Appeal of the East Caribbean described as the primary facts, these are not in dispute. The Court of Appeal encapsulates the position at paragraph 15 of its judgment at electronic 58. In the judgment of Justice of Appeal, the Honourable Mr. Paul Webster, in whose judgment the rest of the court concurred, where he says, "The result is the primary facts in the case are not disputed. The difference between the parties lies in the interpretation of those facts and the legal and factual inferences to be drawn from them." Whilst at that period, the point was the parties before the Court of Appeal were only the appellant and the respondent, as the appellant had paid Mr. Steele the $2.475 million which were an issue. The appellant's submission criticises the consideration by the courts below of the whole structure of the transaction between BAIC, the appellant, and Mrs. Lee. In particular, the omission of a full consideration of the effect of the assignment entered into by Mrs. Lee is submitted to be the flaw in the decision of the East Caribbean Court of Appeal. To put it another way, the Court of Appeal failed to consider fully the structure of the arrangements and contractual mechanisms of what was a somewhat unusual transaction, unusual both in the contractual mechanism chosen and in the interaction of the various contracts. The failure by the courts below to address the whole structure of the transactions arrangements is seen firstly in the failure of the High Court to consider in any depth the assignment entered into by Mrs. Lee at BAIC's insistence, and secondly, the failure of the Court of Appeal to follow through fully what was the effect of that assignment. The High Court's decision omits all electronic to 45. There is reference to the deed of guarantee, the annuity application.
Lord Davidson, I'm afraid to say we lost you for a bit. Your broadband connection failed. So if you could recover the last sentence that you were addressing us on, please.
I was saying High Court's decision omits almost all reference to the assignment. The decision is found at, sorry, Lord Leggatt.
Is it your case, Lord Davidson, that the assignment changed the nature of the arrangement into one of trust?
My Lord, yes.
Or do you,
Together,
you say it was previously not a trust arrangement, but then after the assignment it was, is that right?
no, taking all the documents together, it becomes a trust.
Well, there must have been a position at a certain point in time before the assignment was thought up and entered into, which came after, didn't it? And what I want to know is what your contention is about the position before the assignment.
But the position is this: the assignment was considered before the agreement was put together. There's clearly discussion revealed by an internal memo of, I think, 13th May 2007, where it's proposed that there is going to be an assignment, and it appears an assignment has actually been produced. Now, true it is, the assignment wasn't entered into at that stage, but it's clear that what was envisaged was that the assignment would be part of the collection of transactions that are put together, that I say is a resulting trust. So, if I may go back, sorry,
I'm sorry, Lord Davidson. Upon what date did this resulting trust actually arise?
Well, the assignment was signed on the 22nd of August 2007.
But on what date did the actual resulting trust arise? Because the assignment, you say, I think, is evidence of it rather than being a constituent of it.
Yes, it's part of the constitution of the resulting trust.
Okay.
Is what I argue.
So, upon what date did the resulting trust arise?
Well, there are various possibilities.
And what date do you say?
Here, the assignment is actually finally put together, but the assignment doesn't have a life on its own. It refers back to the annuity and to the guarantee, because these are all put together. The notion was that this series of transactions was a unum quid, that everything was put together to enable payment to Mr. Steele.
Okay, so I missed it. I'm sorry, we lost you a bit. But on what date? The money was paid on the 18th of May 2007. Did the resulting trust arise on that date?
Well, it would, given that the collection of agreements was already agreed at that stage, what I would say is that when the assignment is actually signed, that is merely a reflection of what parties had agreed beforehand. So if the Lord is looking to find what was actually agreed, it would appear that what was agreed would be the case was back in 17th, 18th May.
Okay. Who held the beneficial interest on the 18th of May 2007?
Mrs. Lee.
And does she still hold the beneficial interest?
No. What I argue is that she lost the beneficial interest when it was assigned to Mr. Steele in 2015.
And was the resulting trust then on the 18th of May with a power, and the power was to do what? BICO were to do what with their power?
BICO was to pay the fund to Mr. Steele.
On what date?
On the 18th, 19th of May 2009.
But if it was to pay directly to Mr. Steele, completion was on the 18th of May 2009, not on the 19th of May 2009.
Well, I will come to that, my lord, because the assignment was in terms of payment on the 19th, because the guarantee was not fulfilled by BACO.
Well, if there was an assignment why was there a need for an assignment when there was a power in BACO to pay Mr. Steele in any event? Why didn't he need to assign anything?
Well, this is the oddity of the case. As I say, the unusual features of the case. It appears, I'm not entirely clear why, but it appears that BACO formed the view that there was a risk to them at 18th May 09 in relation to the guarantee. So the assignment was introduced as a protective measure for BACO's interest.
But they didn't need it. They could have, you say that they had a power to pay Mr. Steele. They didn't need the assignment.
But they chose to have it. And when one looks at the assignment, one sees there one of the critical features, and that is the reference to right and title to Mrs. Lee, which I focus on. And
unfortunately, all this contradicts the guarantee and the primary obligation being on Brickley Bay to pay the money.
Yes, but that, I would submit, is not what actually was envisaged when the parties, BACO and Brickley Bay and Mrs. Lee, put the transaction together. The notion that the guarantee was going to pay was in fact departed from, that the mechanism for paying was in fact the assignment.
So in effect, you're asking us to rectify all these documents to accord with something else?
No, my lord, I'm asking the board to put all these documents together and consider the transaction as a unum quid.
Thank you. Thank you.
My lord. Perhaps I would go back to where I was in looking at the High Court decision, but I've maybe fast forwarded a little. I was going to say that the High Court decision, because it omits all reference to the assignment, almost all reference, is part of the problem and the way in which the High Court dealt with the issue. The assignment is referred to by the High Court at electronic 41, which is paragraph 46. And paragraph 46 provides the court finds that BACO had a clear understanding that there was a default by Brickley Bay in the payment of the balance of the purchase price, was obligated under the deed of guarantee to make the payment. This is evident not only from the words of the guarantee, but also from BACO's insistence that Mrs. Lee execute an assignment to the claimant. It can be objectively ascertained from the circumstances of the transaction that the intention of the parties and the essence of the bargain was that the sum would be paid by BACO at a specific time for a specific purpose on the happening of a specific event. That's the only reference that the High Court made to the assignment. The High Court made a finding, in fact, at paragraph 43, paragraph 36 at electronic 39, which stated as follows: in the court's view, both the deed of guarantee and the surrounding circumstances demonstrate that the money paid to BACO was to be used for a particular purpose, that is, payment of the balance of the purchase price to the claimant on default by Brickley Bay. And so that seems to be the purpose is to make the payment to Mr. Steele at that stage. And further finding at electronic 40, paragraph 43, the High Court says BACO was aware of the reasons for the guarantee. The draft consent agreement was sent to BACO. In addition, there was correspondence between the claimant's attorney and BACO prior to BACO's consent to provide the guarantee. So one sees there that BACO had knowledge of the consent agreement. The consent agreement itself indicated that there had to be the provision of an irrevocable bank guarantee, as it said, from Baker for the balance of the purchase price. That can be seen at paragraph 6 of the consent agreement found at electronic 33. At paragraph 46 of the High Court, at electronic 41, there again the court says the court finds that Baker had a clear understanding that if there was a default by Prickley Bay in the payment of the balance of the purchase price, it was obligated under the deed of guarantee to make the payment. This is evident not only from the words of the guarantee, but also from Baker's insistence that Mrs. Lee execute an assignment to the claimant. I've referred that passage before. The High Court concluded, however, at 47 that there was no mutual understanding between the payer and Baker of an intention to control Baker's use of the funds. And that is why the High Court held that there was no quis trust. Now, the appellant's case is that had the assignment been examined more closely by the High Court would have seen the language therein which identified the right and title of Mrs. Lee to what was called the annuity and to the $2.475 million. Had it done so, the High Court would have seen that there was more to the transaction than had been considered. By way of example, the High Court's finding at paragraph 47 at electronic 41, the last sentence of that states, the status and use of the money during the life of the annuity was not addressed. In the absence of a finding of the requisite clear attention, the court cannot conclude that a quis trust has been established. But the question of the status and use of the money, that I submit was wrong, as the assignment dealt expressly with that status, namely that the money was subject to Mrs. Lee's right and title and subject to a condition of non-payment, Mr. Steele, on the 18th May 09. So that had implications also for the use of the money.
Lord Davidson, that submission depends, does it not, on an assumption that what was assigned was the money rather than the benefit of the annuity policy.
Yes, the assignment. Sorry, Lord.
You are having to say that the assignment was the assignment of a sum of money rather than the policy.
Yes, if one looks at the assignment, I will look at it in due course. It does make reference to the annuity, true, but it also makes reference to what is described as the value of $2.475 million. So it's not just simply saying the benefit of the annuity. There is also another reference to this specific fund. So the High Court at paragraph 55, item 5, in electronic 43, held that the guarantee provided, quoting, nothing more than a contingent liability on the part of Baker. That may be correct on a reading of the deed in isolation, but as the English Court of Appeal in the case of Bieber against Teethers teaches, quoting, proper account needs to be taken of the structure of the arrangements and the contractual mechanisms involved. When one turns to the Court of Appeal decision, the Court of Appeal at electronic 61, paragraph 20, stated, this is going through a number of points, says thirdly, the appeal is largely against the findings of the fact by the landed trial judge. That is not the appellant's position before this court, and submit quantum valeat. It was not the position before the Court of Appeal. The Court of Appeal, in making its decision, further expressed itself to be of that view at paragraph 51, electronic 77, where the landed judge said, the fact that British Americans' ability to deal with the fund was decisive in this case is a finding of fact by the trial judge with which the court should not interfere. Now, I submit that the ability to deal with the funds is a matter to be resolved by an assessment of the whole arrangements in place, which is submitted neither of the lower courts resolved correctly. Construction of all the documents constituting the parties' transaction is a matter of law, not a challenge to findings in fact. Neither does ascertaining objectively from the circumstances amount to such a challenge. In particular, the lower courts both failed to assess the interplay of the guarantee, the receipt from Baco, the documentation for the annuity, and Mrs. Lee's assignment. Objective assessment reveals the fund was not treated as Baco's to deal with as it chose, I submit. The Court of Appeal, of course, formed its view adverse to the appellant on consideration of the three matters: intention, segregation, and use. In the expression of intention, the Court of Appeal accepted that this was not decisive of the issue, that at paragraph 37, electronic 70, they observed the ascertainment of intention of the settler, being short, and the recipient must be done on an objective basis, having regard to the documents used by the parties and the circumstances of the transaction objectively viewed. So how the parties express their understanding of the transaction is not determinative. I say this because Mrs. Lee in her affidavit talked term loan and such like. And the second point of segregation, again, the Court of Appeal accepted this not to be decisive. At paragraph 39, electronic 71, they observed that this was good, though not decisive. Now, true it is the parties did not stipulate for segregation, but on one view, that was one consequence of the transactions arrangements. And in relation to use, the court held this to be decisive, and that at paragraph 51, electronic 77. Now, it's not disputed that as defined by the Court of Appeal, that use is decisive. The established facts, however, point to Baco not having free use of the money. So turning then to the submission in more detail, the submission is properly assessed. The transaction did not reveal a power on Baco's part to use the funds as it chose. Now, turning first to the guarantee, this was perhaps an odd arrangement, but was certainly in the way in which matters were initially approached, was to be the mechanism for payment of Mr. Steele. That was certainly in the view of the appellant and Mrs. Lee when the guarantee was first discussed. And that may be seen at electronic 1001 to 1002, paragraph 16. And that coincides with the High Court's finding at paragraph 36, to which I've already made reference. Now, Baco was certainly of the view that payment was to go to Mr. Steele from the guarantee, or payment was to be made in 2009. That can be seen from the letter that Baco produced on 4th May 2009. This is at electronic 153. Now, this is an extremely poor copy of the letter, but one can detect from it certain components. It's addressed to Ms. Wilkinson, who is attorney for, both the appellant and Mrs. Lee. And it's in relation to the deed of guarantee. And it says, we refer to the above and to our obligation thereunder to pay the amount of what looks like $2.475 million on the 18th day of May 2009. Then importantly, I submit, from the proceeds of policy number something, then Rosa Lee. So this is being sent because Baco regard the position as being an inability to pay that sum on the date, and they're offering payment of 10,000 East Caribbean dollars as a proposal. to Mr. Steele, and they ask the tenant to put this proposal to the principal and see what the reaction to it is. One sees there is a clearer copy of the same intentions. Lord Leggett, sorry.
I can't read the date of this letter, but it seems to have been sent after the event, was it?
4th May 2009, my lord.
Yes. So why is it of any relevance to the objective meaning of the documents entered into 2 years earlier?
Well, it shows what Baker's understanding of the arrangement was.
Well, I know, but we're not interested in their subjective understanding of the arrangement, are we?
Well, the proposition that I'm putting forward, that the payment comes from the annuity arrangement, gains support at least from this letter. There's no more to it than that. I take my lord's point. If my lords want a clearer copy, there is, if not a copy of that letter, there is another letter of 13th May, which covers the same point, and that found at electronic 152, which simply substitutes an offer of US dollars in place of East Caribbean dollars. But my point underlying all this is that Baker knew that Prickly Bay was not going to pay Mr. Steele on the 18th of May, and that the question about a default, well, that's technically the case, but Baker knew that the payment was going to be under the guarantee via the annuity. And that there's no contrary evidence from Baker to that effect. No contrary evidence against that effect. The witness testimony was from Mr. Lee and Mr. Steele. Baker didn't provide witness testimony. There was an affidavit from the judicial manager, Mr. John, but of course he was not part to the setting up of the transaction in 2007. His affidavit is found at electronic 924. But going back to the events when the arrangement was set up, the receipt found at electronic 300 states there, received on behalf of received on behalf of Baker to be held under the deed of guarantee. That is not how a bank normally responds to receipt of a deposit. It suggests that Baker did not see the payment as a simple deposit. Held under the deed of guarantee was tying that sum of money to the guarantee. And then there is the annuity, and the oddity, perhaps underlying certain of the questions already put to me, is what was the purpose of this? But it seems to have been twofold. Firstly, to protect Baker, the internal memo at electronic 295 is clear on this, but also as a mechanism to pay Mr. Steele the money. This was arranged by Baker, and the question is what truly was its content and nature. When one looks at the application and puts that beside the schedule of benefits, one's left with a number of oddities as to what on earth was intended and what is the status of each document. The application is found at electronic 284, and the schedule of benefits is found at electronic 288. And if I may direct the board's attention to those documents. .284, the application sets out, running through the various points, it deletes a number of issues, and then at the end at the end of that page has EFPA interest term 2 years at 8.4%. And the following page is simply signed by Mrs. Lee and the Baker.
Sorry, Mr. Davidson. I'm sorry to interrupt. Could you just give me the page reference for this again?
I'm sorry, Lord. It's I've just lost it. The application is at 284 to 285, my Lord.
Thank you very much.
Then, so that one has the application.
Lord Leggett would like to ask a question.
Yes.
Isn't the interest rate a crucial factor, Lord Davidson? Because it shows that this was an investment, doesn't it, essentially, by Mrs. Lee, or for the period until the sum became payable.
Well,
And if they're going to generate 8-point-something% interest, it's hard to imagine how they're going to be able to do that if they don't have free use of the money.
yes, well, that's what the application says, my Lord. But then one goes to the schedule of benefits at 288, and it seems to be something else. This is the annuity. This is part of the annuity document. The schedule of benefits provides something entirely different. A guaranteed annual annuity payment of $153,000 over a guaranteed period of 10 years. So that is what the annuity. Well,
I'm not certain it does do something different, because if you go back to 284, sections 6 and 7 are deleted, and those are the charges for early surrender. And so what was being envisaged was 2 years later, you get your money back plus 8.42%
yes,
on that money. And that's an additional £416,000, roughly.
yes, my Lord. But what then is the schedule of benefits? Because
Well,
what it says is that one gets 153,000 for 10 years in relation to the policy. So this is part of the contract.
But you say there's a conflict between the two. That conflict could be resolved by virtue of the fact that under the document of page 284, you get your money back in 2 years' time plus interest.
Yeah, but that I think doesn't resolve it, because one still has the schedule of benefits with a retirement date. I mean, this is said to be an annuity, my Lord. And an annuity normally is the student. I'm sorry.
I'm just, in one sense, your client goes to an insurance company to get a guarantee, and as opposed to a bank. And in order to get that guarantee, they make an investment in an annuity. I mean, when you say it's an oddity, my understanding is that if there is a lack of evidence, that doesn't establish a trust. What you have to do is establish a joint intention or an intention to create a trust. And so referring to oddities, I don't at present see how it advances your case.
Well, I say this because it's more than just an oddity, because what one has is a guarantee put in place. The money is transferred. The guarantee is seen to be the first notion under which Mr. Steele is to be paid. Then the annuity is put in place at Baker's insistence, and then it is assigned. And then if one's putting these together, it's the point I made earlier, that one has to give some content to what this collection of agreements amounts to. And the part of it is that where one's looking to the mechanism for payment, one sees the express indication in the assignment of right and title being with Mrs. Lee. And what the oddity, if one wishes to continue with perhaps my choice of words, is that Baker does not appear to have fully understood the position in which it found itself. It conjured up the idea that there was some danger of double payment, and there appear to have been different people putting this together. And the arrangement is not a simple normal banking transaction. It's not a simple investment or a payment, would be my submission.
That may be indeed correct, Lord Davidson, but if we stick with the application, we see that what was being applied for was an executive flexible premium annuity, and which was designed to create an accumulated fund over time. But in this case, we have the payment to the insurance company described as a premium. So prima facie, this document, what happens is that the insurance company incurs certain contractual obligations to the beneficiary of the policy in return for the payment of a premium. That is the basic structure of this arrangement, is it not?
Well, that is certainly, of course, not as correct in expressing what the application states, but the application is not the only document, and one I would submit cannot ignore the schedule of benefits.
Well, indeed not. If the assignee of this policy were to decide to take the annuity from 2012 onwards, he would be quite entitled to do so. Alternatively, he could surrender the policy without penalty, as we see from Section 6, and receive back the premium plus 2 years interest. But
yes, but sorry. What I'm stating is that the application is not the whole contract, even in relation to the annuity. Sorry, my Lord Legate.
Should we take account of page 286, for example, which says that the executive flexible premium annuity is an investment product, which basically follows the traditional format of an annuity plan. It gives a higher return to the investor with the interest rate guaranteed and so forth?
Yes, then, oh, I mean, I can keep repeating that the schedule of benefits says something else and forms part of the contract. And the reason I say it forms part of the contract is that electronic 291, where they're provided at paragraph 301. It says the contract, the application, and any riders attached to this contract make up the whole contract. Only the president and secretary of the company signing together have the authority to execute or alter this contract. So the contract as defined is not just the application. It can't be taken in isolation to say, well, that's all there is to it, that's it. One has the material in the schedule, which I submit simply cannot be ignored.
But it doesn't change the nature of the instrument. I mean, if you take the policy at face value, there may be a difference about when you can cash it in, but it's the same basic concept of an investment product.
Yes, but in different terms.
All right, in different terms, but nothing that takes you anywhere near a trust.
No, not on itself. Of course, I agree with my lord on that point, with respect. But what I refer to this, the annuity, is that the overarching intention of Baker was that the annuity was to serve as a means of paying the 2.475 million to Mr. Steele. And then when one comes to the assignment, this found at electronic 296, the question that's already been put to me is what is being assigned? Now, the annuity, as described in the schedule, well, it doesn't appear to be that. So therefore, it's a mechanism of paying Mr. Steele 296. And this was Baker's intention. This Baker's internal memo suggests that the payment by the annuity. The terms of the assignment include such assignment, such right and title shall be to the value of US 2.475 million. That is commencing on the 18th of May 07. Now, this is not the creation of a debtor-creditor relationship, such as maybe found in a normal banking deposit. It's treating the money as a separate fund with an identified owner. In a sense, it reveals segregation. The money is treated as a sum to which Mrs. Lee has right and title, albeit conditionally assigned. Now, I accept that there is a complication that apparently independently from the assignment, there was also an agreement embodied in my Lord Stephens.
What was to happen to the interest, which was nearly $500,000?
But sorry, my Lord, in what sense?
Well, you say that there is an assignment of the annuity so that the annuity can be paid to, or part of the funds from the annuity could be paid to Mr. Steele. But what was to happen to the interest?
The interest is covered with Mrs. Lee receiving interest payment.
So she was still to get the interest.
That was the intention. But what I say is that was an error on the part of Baco in its understanding of the transaction it was putting together. That it had left the right and title with Mrs. Lee, and the fact that it paid interest, true that it did, although it didn't pay all the interest, that is a mistake. My Lord Burrows.
Yes, your focus on the words of this particular assignment seemed to be based on the view that we're talking about an assignment of the actual fund. But that would seem, it's very odd wording to insert the words to the value of, because that would imply to me that one isn't talking about a specific piece of property in that sense. You're actually translating it into the value of that property rather than the property itself. Is that not right? Why insert the words to the value of?
Well,
on your hypothesis.
Yes. Well, I submit that this is capable of a reading that it is the sum of the 2.475. It's entirely clear that the arrangements being put together were not being carried through with the rigor of a conveyancer. One sees that immediately from the schedule of benefits.
No, but I thought your main point, I mean, one starting point would be an assignment would normally, I think, be thought to be an assignment of the actual policy. So you're, as I understand it, trying to show us particular reasons why that would be an inaccurate interpretation here, and that I understood you were going to take us to words that clearly showed that it was the actual, if you like, the fund itself, the property, rather than the personal obligation arising from that. But it seems to me the words "to the value" would indicate rather the reverse.
Well, my submission is that it would be right and title to the fund. My Lord Legate.
But the word annuity is a reference to the contract, isn't it? Not to the fund. That's what it's called, the contract. It's called an annuity if you look at it.
Yeah.
And so it's simply an assignment of the benefit of the contract. That's what it says.
Yes. Well, I accept it says right and title to the annuity issued to Rosa and Gladys Lee, but then such right and title shall be to the value of 2.475.
Well, that's where you run into Lord Barrow's point, which makes it worse for you.
I was trying to make it better. The assignment identifies the premium payment, and the question is who retains the beneficial ownership of that. That I have to say is my submission. If my Lords are against me on this point, then I accept that I'm in considerable difficulty of pursuing the point further. The way I would invite Milosz to characterise this is that it was entirely clear that the appellant wanted the payment to go from Baco to Mr. Steele. But the guarantee was set out with a purpose. The purpose was to make the payment to Mr. Steele. Baco, having received the money, course of receiving the money, decided that it had to put in place further protections primarily for Baco, because they saw that they were going to have to pay Mr. Steele. The question of default by Prickley Bay was not really an issue. Prickley Bay simply were not going to pay. They were relying on the payment being made by Baco. Baco, when it receives the money, puts in place the arrangements, which then bring in the annuity, which then brings in the assignment. And the question is, what was at every stage Mrs. Lee without any beneficial ownership of the money? And the only way can establish that there is some ownership is the reference to right and title. Now, if that falls, if Milosz are against me on that, then I accept that there's a problem in the appellant's case. But the clarity, I say, is that Baco understood the money was to be paid, that the money belonged to Mrs. Lee, Lord Leggett.
How would Mrs. Lee have envisaged that the return to her would be generated? How is that money going to come back to the point? How is the interest payment going to be generated unless Baco itself can make use of the money by lending it or investing it?
But this is why I argue that this was an error by Baco, that in deciding to pay interest, they hadn't understood the system that they'd put in place for the transaction. And one sees the oddities about the position between the contrast between the interest and the schedule of benefits, where there's nothing about interest at all. It's about a stream of income pursuant to an annuity.
Well, it doesn't matter whether it's a stream of income or interest. It's still money that they've got to pay to Mrs. Lee. And how are they going to make those payments unless they can make use of the money that they get to generate a return on capital?
I follow the economic logic of this, the financial logic, but what I'm saying is that in my submission, that was an error by Baco in setting up a system to pay interest. They hadn't understood that right and title remained with Mrs. Lee. And the reason I say that is that when one looks at the document called the documents that are called the annuity, there seems to be tensions going one way and the other. Plainly, Baco had difficulty about what it was putting in place. It wasn't putting in place what was a clear, normal banking transaction, and it made certain errors. And the blunder was to make payment. Lord Stevens.
I'm sorry. Are you saying that there's any evidence that Mrs. Lee didn't want to get interest?
No, my lord, I'm not saying that. She did want to get interest.
Yeah. And then you're back to Lord Leggett's point. How was the interest going to be generated?
Well, my lord, I quite understand how the interest was going to be generated from the fund. What is that the undertaking on the part of Baco to pay interest was an error by Baco, their understanding of the arrangement. If right and title remained with Mrs. Lee, then the notion of interest was a mistake on the part of Baco.
Well, if I can refer you then to page 286, to which Lord Leggett referred you earlier. I mean, what this EFPA appears to be is an investment product which follows the traditional format of an annuity plan, but it's designed to give a higher rate of return to the investor with an interest rate guaranteed. And it's offered in 1 or 2 year bands. So it seems to be what's envisaged is the investor can pay a premium, give the money to Baco, BACO invest it, and depending on whether there is a surrender charge or not, long before the annuity comes into effect, the investor can take his money back with interest on it. So it seems to have been envisaged as an investment product, which might never give rise to an annuity.
Yes, well, the question then is, what was it? Was it not? It wasn't an annuity. It was simply a loan by Mrs. Lee to the bank. And I mean, I can understand why that is what the respondent argues, but it comes back to the same point, that if one looks only at the application, then the Lord is of course right. But my submission is one can't look only at the application, because, as is stipulated, the contract includes the other documents. And
But yeah, I see that. I see that point, but the fact is, BACO chose to deal with its security for payment of the guarantee by setting up what was an insurance policy with the payment of a premium and the option, or rather than taking out an annuity, but just to have a fixed term insurance policy and take the growth of the accumulated fund at the end of the 2-year period, with the principal sum being assigned, as you've shown us the assignment, to Mr. Steele, and one assumes the interest going to Mrs. Lee.
My Lord, yes. But it comes back to the interpretation of that demonstrated that right and title was to the fund rather than to what? A loan by Mrs. Lee? Or is it the annuity, or what is it? What is clear, I submit, is that it is the sum of money, the fund, which is consonant with what everybody had understood, namely that the payment was going to come from BACO to Mr. Steele.
I don't think anyone's suggesting it's a loan. I think the suggestion I'm making is that this was an investment with a guaranteed rate of return, and the insurance company had an obligation, if there was a surrender before the annuity was taken out, to pay the accumulated sum. I think that there's a description somewhere of there being an obligation to give an annual statement of the accumulated sum, pay the accumulated sum on surrender. Yes, the accumulation account, it's on page 286. At least once a year, you will receive a statement which would include the deposits made, interest credited, as well as the amount of the accumulation account on the statement preparation date.
Yes. Well, my point, Lord, is that one should not submit the annuity to analysis on its own, because it is part of the whole series of documents that were put together to enable the payment of Mr. Steele.
Yes.
And I guess by now my lords have my submission as to where I'm going with this.
Yes.
I can only say it so many times. Well,
but your case is that there was a trust applied to the proceeds of the annuity, as and when the amount was due, then there would be a call on the annuity, and the trust would then fructify.
Lady, yes.
So it goes back to Lord Stephen's question of when did the trust arise? At the moment, it looks very much as if the annuity arrangement was designed to do that which the bank was anxious to do to protect its own interests, namely put up a system whereby it was only liable as a debtor, if called on.
Yes. Well, what I submit is that the system was that the guarantee was never going to actually be worked in terms of waiting for default and then putting guarantee forward. The intention was that the payment would be made, that the mechanism to make that payment would initially have been a guarantee, but because Baker considered that this was risky in some way, that the transaction went beyond that and created what I say was a beneficial interest in the fund, adhering to Mrs. Lee on a construction of all the circumstances and the document.
An immediate interest. Thank you.
I think you, in answer to Lady Arden, said the trust related to the proceeds of the annuity. It doesn't relate to the premium paid. It relates to the proceeds of an annuity. And I was just wanting to make absolutely certain that I understand that correctly.
Yes,
because this annuity has absolutely no proceeds at all, potentially.
I misspoke, Lord.
Sorry?
I misspoke.
You misspoke. Right.
It is the fund. It is the fund. It's not
Right.
working through an annuity for 20 years, 10 years.
Let's analyze that. Is it the actual money that was paid that is the original payment, so that the fund attaches to the money originally paid, or does it attach to the proceeds or the amount that you get under the annuity?
Well, my submission is it is the original amount paid, because the original amount paid was the 2.475. The right and title is to the 2.475. It's not to the annuity value or the proceeds of the annuity.
Then why buy an annuity?
Well, Mrs. Lee had no intention whatsoever to buy an annuity. This was imposed on her by Baker. This was entirely a Baker arrangement.
But the representative of Baker was actually in the offices of Mrs. Lee's own solicitors, Wilkinson's, at the time that the arrangement was entered into.
Yeah. But nonetheless, it is Baker imposing this notion on Mrs. Lee. I don't mean in the sense of taking advantage of her, but it was their idea, put it more neutrally. It was their concept of a way of developing the transaction. But
agreed to by her, with an ability to obtain legal advice if she so wished.
Yes, well, of course I accept that, my lord.
Yeah.
But she was in a position where she understood the guarantee to go through. If Baker wanted this as the mechanism for having the payment being made to Mr. Steele, then she was going to go along with it. And I mean, one sees it being noted in the evidence that she assumed this was just a Baker internal matter to enable the payment to be made. There wasn't any question of her seeking an annuity. So to try and pull together what I was saying was that in relation to the assignment, my argument is that right and title remained with Mrs. Lee, while the condition remained unpurified, namely the non-payment by Prickly Bay. And that remained thus until the 18th of May 2009. And certainly this is not a normal banking transaction. And my argument is that the transfer of the 2.475 by Mrs. Lee to Baker was made with a clear purpose of paying Mr. Steele in 2009. It wasn't an ordinary bank deposit. The receipt identifies the money as, quote, as to be held under the guarantee. Plainly, the money was of a different status from an ordinary deposit. The receipt may or may not have recognition of segregation of the money, but it suggests a different status from a deposit. And with the annuity, so-called annuity, the money does take on a different status, described first as first premium in the schedule at electronic 288, or premium in the application at 284. But these descriptions, I submit, do not reflect objectively what was intended, namely that the money was to go to Mr. Steele in 2009. The appellant was not going to make another separate payment to Mr. Steele. Baker was to pay. And Baker certainly understood that there were circumstances in which it would require to pay Mr. Steele. And the whole annuity assignment documentation had the purpose of enabling payment of Mr. Steele from the money held by Baker under the guarantee. So the assignment is, in my submission, the critical document, in that it shows Baker recognised right and title remained with Mrs. Lee, but objectively in context, it was recognising the money, the premium remained with Mrs. Lee, albeit subject to a condition coming into effect in May 2009. There was neither truly a term loan or an annuity, nor a guarantee in this sense. Allowed.
I agree it isn't a straightforward annuity, this contract, but looking at the provisions of it, they seem to be entirely consistent with the general description that we looked at of the product, in that on page 289, I see there's an accumulation account in which money is accumulated and interest accrues. And then on page 290, you have various payment options. Basically, it seems that if you don't elect for something else, then it's going to become an ordinary annuity. But it seems that in this particular variation of it, the plan was, or the arrangement was, that it would be paid out after the 2 years. So effectively, it's a loan, isn't it, or a deposit for 2 years, which could have converted into an actual annuity. But on the arrangements that were made, it didn't and wasn't intended to.
If it wasn't intended to be an annuity, it's odd that Baker describes it as an annuity and at each stage invited the application to be for an annuity.
Well, you've got to look at what the actual instrument is, though, haven't you? Not just what the overall description is. It has a number of payment options.
Yeah. Well, Lord, if it's a deposit that somehow is also a loan and investment product that then is in the context of the documentation, apparently an annuity, it is a mighty odd document. It's a mighty odd instrument which has this capacity to morph from being a loan to an annuity at some stage.
Well, I question whether it can be properly characterized as a loan, but it's an insurance product. You're giving your money to the insurance company for a fixed period of time, or at least you've got the option to limit the period of time. You've got a guaranteed rate of interest over 2 years. You can surrender the product at that stage and take what's in the accumulation account, or you can elect to take an annuity. So the options, it's a bit like a short-term endowment policy for a couple of years, which failing, you can take an annuity thereafter. It is an insurance product.
Well, obviously I hear what my Lord says. Lord has my submission as to when one looks at the whole fasciculus of the documentation, it is not that.
But I'm finding it odd that you say that this was an odd transaction. The bank, considering its own interests, had to be sure that there was nothing that gave rise to an impression that there was a segregated amount which could be said to be on trust for Mrs. Lee, because it might end up paying under the guarantee, which is given as an obligation to Mr. Steele. So is it very odd that it comes up with the annuity? Because the annuity...
I would say submit, because one looks at what was envisaged. The guarantee meant straight payment to Mr. Steele. Now, no particular problem with that plain vanilla transaction. Baker then perceives that there is a risk to Baker that they may have to pay twice. Now, that does seem strange. All they would need to do is say, well, has for example, Prickly Bay been in default, in which case we have to pay Mr. Steele. The guarantee is operated. And Mr. Steele would presumably turn up and say, well, I want my money, as he did. And if they then paid Mr. Steele, then that would be the end of the guarantee. How it turns out to be a double payment, I submit is slightly difficult to understand. But that is what Baco thought. And therefore the oddity is that, perceiving this risk, they then decided to put in place further instruments which they thought would enable the payment directly to Mr. Steele without any risk to them.
I suppose there might be a dispute between the parties when the guarantee was called upon, and the bank would be obliged to pay because of the simplicity of the guarantee and its obligations as banker. But then Mrs. Lee might demand the sum back on the basis they had paid prematurely when there were cross claims against Mr. Steele or something of that nature.
Well, I suppose there are many possibilities, but certainly Mrs. Lee's understanding was that the money would go straight to Mr. Steele at the time which the transactions were put together.
And there's another fundamental point about your submissions, namely that you're asking us to overlay the parties' understandings and expectations and overlay them over the documents. To do that, we have to be satisfied that the documents should be interpreted according to those understandings and expectations, rather than in accordance with their tenor. And is that the case?
Lady, no, but one is entitled to look at the whole circumstances, because the documents don't exist in a vacuum. They're put together for a reason.
Yep. They must be interpreted against their matrix of fact.
Lady, yes.
Which would include objectively the aim and genesis of the transaction.
Lady, yes.
Thank you. Thank you.
Lady.
Can I, Mr. Davidson, could I ask a question? Accepting for the moment that all the documentation interpreted together is designed to ensure payment to Mr. Steele, and that seems to be the tenor of what you're saying. And we accept that it's been an odd way of going around things, but nevertheless, that's what the documentation would indicate on your submission is all about. Isn't that only the starting point? Because you would then have to convince us that all that odd contractual relationships actually reveal something more, which is that there's a trust being set up. Because at the moment, I can't see why, even if we're with you on this, reading all these documentations together, and that the whole purpose is just to ensure payment to Mr. Steele, why that gets you over the line of saying we've got to go, in a sense, behind all this to a trust.
Well, I don't say one goes behind it. One says one looks at the assignment on its face, and the reference to right and title being with Mrs. Lee. That's indicative of beneficial ownership and hence resulting trust. I appreciate that my Lord looks at the assignment slightly differently than the way I'm suggesting that it should be looked at, but against the background of what the purpose of all this was, I submit that.
Yes, well, I don't want to repeat the point I think Lord Leggett made it, but that would strike me as relatively straightforward, ordinary terminology just to describe an assignment of an insurance policy. But anyway, you've made your submission on that.
Yes. And the only thing I would say is that it isn't assignment of an insurance policy. It separates out the premium figure as a sum of money. The arrangements of the transaction are perhaps not well used, but if I could remind the board of a statement by Lord Millett in Twin Sector, this at electronic 1570, paragraph 101, which his lordship made in relation to certainty. I can just find it in the notes. Lord Millett said there at 101, after a long exposition and so on, a trust must have certainty of objects, but the only trust is the resulting trust for the lender. The borrower is authorised or directed to apply money for a stated purpose. This is a mere power and does not constitute a purpose trust, provided the power is stated with sufficient clarity for the court to be able to determine whether it is still capable of being carried out and whether the money has been misapplied. It is sufficiently certain to be enforced. If it is uncertain, however, then the borrower has no authority to make any use of money at all, and must return it to the lender under the resulting trust. Uncertainty works in favour of the lender, not the borrower. It cannot help a person in the position of Mr. Lee. So, to the extent that the arrangements are curious and uncertain in their overall effect, I submit that uncertainty operates in favour of the appellant. If I may turn to the respondent's case, the respondent approach is to follow the reasoning of the Court of Appeal, but in so doing, I submit it doesn't address the full significance of Mrs. Lee's assignment. The respondent argues that there is nothing in the policy, the annuity, that anticipated payment to Mr. Steele, but that ignores the assignment. And it's essential, of course, to read the documents together. The respondent focuses on intention, that as Lord Millett observed in Air Jamaica, and I think the passage is in Air Jamaica, which is at electronic 1200, and this at page 1412, Lord Millett observed, but it, meaning a resulting trust, arises whether or not the transferor intended to retain a beneficial interest. One notes also the 4th May letter. I hear what the Lord Legate has said in relation to that, so I will not press that further. But the respondent offers two possible characterizations of the payment at 12.4 of the case, that's electronic 1176. And that's either as taking out a normal annuity or a normal 2-year loan by Mrs. Lee. And I submit neither reflects the full nature of the transaction. And what is described as the annuity or whatever was in fact a device put in place by Baker to enable it to pay Mr. Steele and to avoid paying out twice. As regards being a loan, one may note that Lord Millett in Twin Sectra at paragraph 100, electronic 1569, despite the transaction there being described as a loan, that did not preclude the finding of a resulting trust in that case. I would also draw reference to the paragraph 68 at electronic 1561. His Lordship says, 68, money advanced by way of loan normally becomes the property of the borrower. He is free to apply the money as he chooses, and save to the extent to which he may have taken security for repayment, take of the borrower's insolvency. But it is well established that a loan to a borrower for a specific purpose, where the borrower is not free to apply the money for any other purpose, gives rise to fiduciary obligations on the part of the borrower, which a court of equity would enforce. In the earlier cases, the purpose was to enable the borrower to pay his creditors or some of them. The principle is not limited to such cases. The respondent argues at 12.5 of the case, it's electronic 1177, that a trust could not have been intended by reference to business sense and to the payment of interest. This ignores my submission that the possibility that Baker simply misunderstood the full legal consequences of what it was putting in place obtains. And it appears internally at Baker there was at least an element of confusion to the transaction. Full charge of but did not clearly analyse the consequence of the instruments it chose to deploy. In such circumstances, the full legal consequences resulted in Baker not applying sound so-called business sense, with the result it paid out interest on an unsound understanding of the transaction. There is a new argument
You're putting this in terms of what they did or didn't understand, but that isn't actually the point, is it? We have to look at the arrangements objectively. And what your submission amounts to really is saying we ignore part of the arrangement because it doesn't fit with your submission, and treat that as somehow something that doesn't count.
Well, no, I'm not inviting the board to ignore the interest payment. I'm asking it to be characterised as an error, as a failure to understand the transaction in total.
Well, it's just another way of saying the same thing, isn't it?
I'm using slightly different words, my lord.
Yes. No.
I was going to say that finally.
But I do apologise, Lord Davidson, but some of these arguments are a sort of reverse burden of proof, because when you say there's an oddity, you want us to assume that there is a trust, whereas I understood that you have to establish that there is a trust. So if there is confusion, if there is chaos, it doesn't help your case.
Well, where I would found on is saying, referring back to Malaw's observations about uncertainty. What I say is that there's plainly uncertainty here, that the language of the assignment, for example, it is, I submit, is not absolutely clear that that means the fund was not the subject of right and title. So if
that can't help you though, because the paragraph you showed us said that the trust has to have certainty. Well, it was talking about the possibility that the power may be uncertain, in which case the money just comes back. But there actually is no uncertainty in this case about the obligation to pay Mr. Steele. But all the paragraph was saying was that if it had been uncertain, and you have a trust in the first place, if it had been uncertain whether the money should be used to pay Mr. Steele, then it would come back to the person who set up the trust. But only A, there was no uncertainty of that kind, and B, it would only be relevant if you did have a certainty of objects about the trust.
Mm-hmm. Well, the uncertainty, I submit, is what was actually being put together. And because one can't identify, I say clearly, what was actually put together, when one discovers the indication that the beneficial interest remained with Mrs. Lee, that is sufficient to indicate the foundation of a trust. But Malaz has my submission on that. Malaz, I note the time, but I can complete or I can pause at the moment if Malaz wish.
Lord Davison, how long do you expect to be?
2-3 minutes would cover it, my lord.
Well, then we'll postpone our adjournment to allow you to complete. Thank you very much.
Well done, obliged. I was going to refer to a new argument that's advanced by the respondent at its paragraph 13 at electronic 1180. And this is advanced by the respondent on an ESTO basis. It is that enforcement of the trust is not within the appellant's capacity, as if it is transferred to Mr. Steele, then he has been paid, the assignment is no longer operative. And my answer to that, I submit, is as follows. The assignment to Mr. Steele was effective as at 19th May 09 due to non-payment to him on the 18th of May. And that the further assignment by Mr. Steele to the appellant, that's found at electronic 103839, was made in consideration of the payment by Prickly Bay to Mr. Steele of the 2.475 million. So that the trust had not disappeared before Mr. Steele's assignment to the appellant. Mr. Steele assigns to the appellant. Thus, the assignment, I submit, to Mr. Steele was effective, and the assignment by Mr. Steele to the appellant was effective, and therefore the non-enforcement point falls. So in conclusion, my point is that the sum of 2.475 million was the subject of a resulting trust in which Mrs. Lee was the beneficial owner. The assignment of trust money to Mr. Steele was effective as of 19th May 09. And Mr. Steele's assignment to the appellant on 5th November 2015 was also effective, and accordingly the board should allow the appeal. If the board were in my favour, matters of interest might remain to be dealt with separately in due course. Lars, my lady, that would complete my submission.
Lord Davidson, I'm most grateful to you for your submission. The board will adjourn in a minute, but we will adjourn for 15 minutes so that we can take stock of where we are. That involves you simply switching off your video and microphone, and we will go into a separate meeting. Thank you very much. The board is now ready to resume. Mr. Bennett, we do not need to call upon you for your submissions. Thank you very much.
Thank you.
The board is very grateful to council and those who have assisted them for their written submissions and the preparation of the documents. We are also grateful to Lord Davidson for his focused oral submission, which has covered everything which I think can properly be said in this appeal. The board will take time to consider what advice it will humbly tender to Her Majesty, and the board will now adjourn. Thank you very much.